I'm Kristen Page. I'm the owner, designated broker, and market coordinator for Texas Trade Days. Today I would like to go over the 2024 Texas Trade Days vendor rental agreement and policy. Whenever you go to the website at www.texastradedays.show, it will take you to this page. You'll scroll down, select Become a Vendor to go to our vendor information page. Here you will find a little bit more about us, and then you'll find some quick links. Then you'll find the 2024 TXTD vendor rental agreement and policy, which is the web copy, as the second link under the quick links. This is also the policy that you will read and sign that is attached to the application that you submit to become a vendor at any of our markets. So let's review the 2024 Texas Trade Days vendor rental agreement and policy. You can follow along. You will see that it has the current copy. I will always make sure that you will see the current copy, which will coincide with the version that is attached to the vendor application. Number 1, Commercial Real Estate Lease Agreement. Commercial tenant vendor acknowledges they are submitting a commercial real estate rental application, agreement, and policy agreement, and rental payment to K.M. Parker Enterprises, LLC, Company, for the dates selected by the vendor. This agreement only covers the leased space and applicable services required for the leased space. The company reserves the right to update this agreement at any time. Vendor will receive a PDF copy of the agreement upon their online submission of this agreement to the company. Number 2, applicability. This agreement applies to all rental spaces vendor leases from the company for 2024. Vendor is required to sign a new 2024 vendor rental agreement and vendor policy upon any changes made to this agreement. Number 3, compensation. Vendor agrees to the payment they made for the rental space type vendor selected on the Texas Trade Days website, PDF, or in-person application in which this agreement is attached. Failure to pay for the rental space selected results in the vendor not receiving the rental space. Compensation to the company is based on the price per square foot charged by the venue and includes additional services required to lease space, payment processing fees, and to operate the market for vendor to sell goods directly to the public. Number 4, license holder disclosure. The Texas Administrative Code 535.144, known as the Texas Real Estate Commission Rules, requires a license holder acting on their own behalf while engaging in a real estate transaction to disclose they are a license holder to the other party before entering into a rental agreement. Disclosure. K.M. Parker Enterprises, LLC, is a business entity licensed to conduct real estate brokerage activities in Texas. Kristen Page is a Texas real estate broker license holder authorized to conduct real estate brokerage activities on behalf of the company. Number 5, company filings, permit, certification, and association. The company maintains the following in addition to above licensing in relation to the operations of the company. Limited Liability Company, Texas Secretary of State. Copyrights reserved, U.S. Copyright Office. Texas Trademark, Texas Secretary of State. Texas Food Manager Certification, Texas Department of State Health Services. Texas Food Handler Certification, Texas Department of State Health Services and Local Requirements. Texas Sales and Use Tax Permit, Texas Comptroller of Public Accounts. Number 6, venue occupancy. The company leases and occupies property with the written permission of all property owners through commercial real estate lease agreements. The company is responsible for adhering to property owner, venue, rules and ensuring compliance from vendors. All company inquiries are handled by the company. All wishing to confirm lease agreements can contact the venue at the locations in which the markets take place. Dates, times, locations are subject to change at the discretion of the venue and/or the company. Number 7, market dates and availability. The company schedules market dates and times that are in the best interest of the company and its customers. Schedules are announced when available and are released at its discretion. Market dates, times, and locations are subject to change. Number 8, weather conditions. Texas Trade Days markets are rain or shine. Be prepared for all types of weather. Abide by the suggestions made by the company. Repeated health and safety risks, even during a single market, may result in the vendor not being allowed to continue the current market without refund. Number 9, Texas Trade Days advertising. The company advertises and markets the company and its marketplaces to attract and maintain general marketplace customers, promote positive community involvement, and generate additional foot traffic for marketplaces. Costs of marketing are included in the gross rental space price and are non-refundable. Number 10, market sales size and traffic. The company does not estimate, guarantee, nor is responsible for vendor sales, customer traffic, or vendor rentals and attendance amounts, regardless of whether the market is small or big, or not in accordance with customer or vendor expectations. Number 11, advertising by vendors. Approved vendors are responsible for their individual business advertising for each market they have leased space. Vendors are recommended to share Texas Trade Days market flyers, social media event listings, invite social media friends to social media event listings, and other promotional activities for the market dates they are approved. Vendors should not mislead the public by advertising inaccurate information that deviates from advertising made by the company. Vendors are not authorized to create their own events on social media or by any means for any company markets, but may add the company social media events to their business pages and accounts. The company provides vendors with social media events, flyers, photos, and other promotional items vendors are authorized to distribute through the website. Vendors shall not mislead any persons or organizations into believing they are a representative of the company in any way. Any vendor found to violate this section shall cease and desist immediately. The company is not responsible for outdated, misleading, or inaccurate information shared by the vendor. It's the vendor's responsibility to stay current with any changes made by the company. Number 12, space rental adjustments. The company reserves the right to adjust space rental prices and vendor space location at any time. Approved vendors are not responsible for or entitled to any price difference from the amount they originally paid. Vendors may receive the same or similar space location or better. Vendors are not entitled to any refund in the event venue fails to meet their obligations. The company is not responsible for the failure of the venue to meet its obligations. Number 13, market photography. The company may photograph and record the venue vendors, guests, customers, and events during the normal course of business to advertise and or market the company markets. The company reserves all rights. Commercial licensing is extended to approved vendors to use their specific photographs taken by the company for their use in advertising and marketing. Costs of the commercial licensing are included in the gross rental space price. Number 14, vendor applications, agreements, and payments required. Vendors are required to submit applications, agreements, and payments for space rentals. The company does not issue payment invoices, request for payments, etc. in lieu of a signed agreement. Vendor agreements must be completed prior to the market dates and before the vendor is allowed to set up for each market. Vendors are to make payment through the approved forms of payment upon submission of the agreement. The company may accept agreements via in-person, mail, and or email in lieu of the online application in cases of internet or website failure, or at the request of the vendor with approval, or as determined by the company. Paper applications and agreements must be mailed to K.M. Parker Enterprises, LLC, attention Kristen Page, P.O. Box 776, Dickinson, Texas, 77539, and be accompanied by a money order or cashier's check paid to the order of K.M. Parker Enterprises, LLC, for the amount indicated on the vendor's application, along with a self-addressed stamped envelope. Incomplete agreements and agreements without signature, non-accompanied agreements and/or payments, an unapproved request for mailed or in-person arrangements will not secure/reserve a vendor rental space. Insufficient payments will result in the vendor receiving a rental space size the payment amount will sufficiently cover. The company will issue the vendor a refund of the difference in cost, if any, minus fees. Deadline to submit the agreement and payment is 12 p.m. Friday prior to each market date, in the event that the company accepts in-person agreements and payments. Vendor rental spaces are leased on a first-come, first-served basis at the time of market. Number 15, requesting additional rental space at market. Vendors may request to receive additional rental space at market and are responsible for the additional amount owed for the additional rental space, and payment is due immediately upon the vendor's request. Number 16, agreement to copy employees. Vendor agrees to forward a copy of this agreement to all employees and helpers of the vendor. By signing this agreement, vendor certifies they have read, understand, and agree to abide by this agreement. Vendors are responsible for the actions of their employees and helpers. A violation of this agreement, venue rules, laws, etc., by any employees and/or helpers is considered a violation of the vendor. Number 17, vendor application fee. The application fee is a non-refundable charge for processing and advertising the vendor and is equal to 1/2 the total gross rental space price of each agreement submission. The application fee is charged for each lease agreement submitted to the company. The application fee is not transferable to other vendors, agreements, and other market dates not selected at the time of submission and is non-refundable. The application fee for approved vendors is fully applied to satisfy the gross rental space payment made by the vendor. Number 18, age requirements. Vendors must be 18 years of age or older to lease rental spaces at Texas Trade Days markets. Minors under the age of 18 must be accompanied by a parent or legal guardian whose name the agreement must be submitted. Number 19, vendor items. All merchandise and promotional products intended to be sold or distributed at Texas Trade Days markets must be listed on the agreement. The company reserves the right to prohibit the sale or distribution of any merchandise or promotional product at any time. Vendor is required to leave at home or immediately remove prohibited merchandise and promotional products from the market upon instruction by the company and/or the venue, whether verbally or in writing. Number 20, vendor prohibited items and information. The company strictly prohibits the following items to be sold, traded, distributed, displayed, possessed, and/or consumed at any Texas Trade Days markets. Prohibited items include, but are not limited to, all animals, firearms, and ammunition, knives, swords, brass knuckles, nunchucks, any items with the intended or perceived use to be a weapon, pornography, smut, provocative items, sexually explicit items, any item intended or perceived use to be a sexually explicit item, drugs, illegal or controlled substances, Delta 8, kratom, tobacco, and/or associated paraphernalia, smoking pipes, bongs, hookahs, any item with intended or perceived use to be a drug and/or tobacco paraphernalia, all alcohol and related information, all potential copyright infringement items, any flea market type wholesale or resale items, all gang-related items, any items deemed inappropriate by the company and/or the venue. Prohibited and inappropriate items, whether new, used, antique, vintage, etc., found during the market will result in the immediate removal of the items. Refusal to remove the prohibited items will result in the vendor's loss of rental space and removal from the grounds immediately without refund. Unlawful drug or alcohol possession or consumption is strictly prohibited. The company reserves the right to discontinue the vendor's participation in Texas Trade Days markets at any time there is concern whether the vendor has sold/promoted, currently sells/promotes, or will in the future sell/promote prohibited items and or information, as well as concerns for unlawful drug, alcohol, possession or consumption by the vendor and or their guest without refund. License to carry holders must abide by all applicable laws, posted signs, law enforcement instructions, the company and or venue requests. Number 21, hazardous equipment and products. Includes but is not limited to electric combustible generators, heaters, fans, warmers, lighting, printers, engines, fryers, stoves, hot plates, microwaves, flammable, volatile, etc. Any hazardous equipment and product must be pre-approved by the company. If approved, the items must be kept away from children, customers, other vendors, and other items potentially affected by the hazard. It must be contained to the vendor's rental space, must not emit toxic vapors, must be kept well ventilated, and must be used in accordance with the manufacturer's intended use. The company reserves the right to discontinue vendor use of any hazardous equipment and is not responsible for loss of power to the vendor rental space, loss to vendor sales, damage, or injury as a result of the vendor's use or discontinued use of the hazardous equipment. The vendor is required to submit a certificate of insurance listing K.M. Parker Enterprises, LLC, as an additional insured for the policy covering the hazardous equipment prior to the vendor's use of the equipment. Failure to provide the certificate of insurance prior to the use of the equipment will result in the vendor's immediate removal of the hazardous equipment from the market. Vendor's refusal to remove the unapproved hazardous equipment from the market will result in the vendor's removal from the market without refund. Number 22, approved vendors. The company deems a rental agreement approved when the vendor agreement is complete, vendor payment has been posted by the payment processor, vendor meets all the company agreement requirements, and the market dates are available to the vendor. Vendors paying by e-check, bank account, not credit card, risk the chance of denial of their rental agreement due to delayed payment processing by the payment processor. The company does not reserve rental spaces without receiving a signed agreement and posted payment. Approved vendors can check the company website for market details and will receive the market details via email no later than the Monday prior to the approved markets listed on the vendor's agreement. Number 23, denied application items. Any product or service listed and or shown on the vendor's agreement may be denied being present and or sold at the market. The vendor will be notified through email for denied items. The vendor may still participate at the market without the denied items present. Failure to abide by this section results in immediate removal of the vendor and products from the market without refund. Number 24, denied vendors. Vendors may be denied based on prohibited items, unavailable rental spaces, incorrect or incomplete agreements, violations of this agreement prior to market day, and permanent denials. Refunds are issued to denied vendors minus the application fee and non-refundable payment processing fee. Number 25, limits on vendor product types. The company reserves the right to limit product types at any time and not at the request of the vendor. The company does not provide any vendor with exclusive rights to sell a product at the market. Number 26, MLM direct sales vendors. MLM vendors are responsible for checking the company website to ensure they stay in compliance with their company. The company is not responsible for the vendor's failure to check the status and availability page of the company website, misreading the status and availability page, or any double booking as a result of the vendor's failure to comply with their company rules. The offending vendor is subject to the decision of the original vendor. The company will issue a refund of the rental space paid by the offending vendor minus fees incurred or charged by the company. Number 27. Corporate vendors not accepted. Corporate businesses include but are not limited to all corporations, large storefronts, information-only vendors, energy, cellular, financial, personal services, education programs, political organizations, and charitable organizations. No exceptions are made to this policy. Number 28. Commercial food vendors not accepted. Applies to any food truck, trailer, or booth, and includes restaurants' on-site food preparations for on-site public consumption requiring a commercial kitchen and/or temporary food establishment permits for operation. Number 29. Texas Cottage Food Law, canning, honey, and farm vendors. All vendors must comply with the applicable local, state, and federal laws regarding the handling, preparation, and sales of their consumable products. Honey altered or flavored in any way is not accepted. Vendors are required to obtain and maintain all required licensing, certifications, and permits, including the Texas Food Handler Certificate and Texas Sales and Use Tax Permit, which is required to be displayed at market. Vendors must have the required labeling and packaging for their products in accordance with the Texas Department of State Health Services. More information about the Texas Cottage Food Law can be found at the following link. You can click on it. The vendors wishing to provide samples must pre-package and label all samples given to the public in accordance with state law. The company reserves the right to check the vendor's products for compliance at any time. The company is not responsible for any action of the government against the vendor relating to the vendor's food business before, during, or after market day. Refer to the Texas Department of State Health Services at the following link. You can click on it, or the appropriate local health department. Kristen Page Parker is a certified food manager through the Texas Department of State Health Services, ID number 2019 M3165720. Number 30. Vendor licensing and permits. Vendors are responsible for obtaining all required licenses, permits, etc. to conduct their business. Vendors are also responsible for displaying these legal documents to the public during all Texas Trade Days markets they participate in as required by law. Vendors must display their Texas Sales and Use Tax Permit for all taxable goods and services sold at the market. Note: it is your responsibility to obtain a Texas Sales and Use Tax Permit as required. Please refer to the Texas Administrative Code 3.286, subsection B1. The company may request copies of these documents at any time. More information can be found at the Texas Controller's Office website at the link. You can click on it below. The company is not responsible for the vendor's failure to obtain or maintain legal requirements or any business closure or shutdown by any regulatory agency. Any vendor required to cease business at market forfeits their rental space payment made to the company for the market and shall leave the premises immediately. Vendors not knowing where to obtain these items are recommended by the company to seek advice from an attorney. Number 31. No vendor space sharing. Rental space sharing is not permitted by the vendor. One vendor company per rental space. Number 32. No vendor subleasing, assignments, or fill-ins. Vendors are strictly prohibited from selling, assigning, or requesting fill-ins of their rental space to another vendor for any reason. The company only authorizes vendors to participate in the company markets in which an agreement is on file. Vendors caught subleasing, assigning, or filling in rental spaces are prohibited from setting up at markets. Employees must be included in the vendor's agreement. Vendor is responsible for their employees assigned to work at the Texas Trade Days markets. Number 33, vendor rental space assignments. Vendor space assignments are given according to the rental space size and location which the vendor selected. If the company does not provide rental space assignments for the market, vendors may choose their specific rental space location upon arrival to market. Vendors must set up next to each other and not leave noticeable gaps between each space. Vendors may choose to switch spaces with another vendor at any time during setup. The company reserves the right to relocate vendor to another similar space at any time to meet the needs of the market. Number 34, vendor space limits. Equipment, displays, merchandise, etc. must be kept within the vendor's designated rental space. Vendors have the option to rent additional space if available. The company reserves the right to keep the vendor within their designated rental space and/or charge the vendor for the additional rental space needed during the market. Number 35, vendor space music. Vendors must have a commercial license to play music other than from a public radio broadcasts. Music must not be heard beyond the vendor's rental space, nor disturb neighboring vendors. Mature content, explicit versions of songs, etc. is prohibited. Amplified music is prohibited without proper permits. Number 36, vendor space design. Displays, space design, and sales techniques shall not interfere with other vendors in any way. The company reserves the right to have the vendor change their setup as needed. Number 37, vendor structures. Vendors are prohibited from erecting permanent and semi-permanent structures in their rental space. All structures must be temporary in nature and shall not be affixed in any way to the ground, walls, ceilings, nearby structures, vehicles, etc. Number 38, vendor equipment. Vendors are required to provide their own equipment, tents, tables, chairs, displays, decorations, products, etc., for their business operations. Equipment examples and recommendations can be found on the Vendor Learning Series section of the website. Number 39, vendor tents. Required for all outdoor spaces. 10 by 10 straight leg canopy tents are required. Business or product logo covers are allowed. Indoor use of tents is prohibited. Number 40, vendor tent weights. At least 40 pounds of weight per leg is required for outdoor tent use, including open pavilions. Retail bagged sand, fitness-free weights, improper weight amounts, lack of weights, unsafe use of concrete cinder blocks, and the use of stakes are not allowed. The company reserves the right to require the removal of improperly weighted tents at any time. Number 41, vendor common areas. Vendors are required to keep all common areas free from equipment, storage containers, vehicles, trash, and debris. Number 42, vendor organization. All storage and product boxes must be kept hidden under covered tables in authorized market storage areas or in vehicles. Displays, products, storage containers, etc. must be confined to the vendor's rental space only. Rental spaces shall be kept neat and clean at all times. Vendor is responsible for maintaining a clean rental space as well as properly discarding and removing trash. All vendor items, including trash, must be taken with the vendor at the end of the market. Any items left behind may be relocated or discarded by the company and/or the venue. The company is not responsible for any loss as a result of the removal of the vendor's property at the end of the market. Violations of this section result in the vendor being invoiced a $250 cleanup fee and/or permanent removal from the market without refund. Vendor's failure to pay the invoice will result in the unpaid invoice being submitted to a collection agency and permanent removal from the market. Number 43, vendor trash. Vendor is responsible for properly cleaning and discarding all waste within and surrounding their rental space. All trash created by the vendor must be taken with the vendor at the end of the market. Vendors who fail to clean their area will be invoiced a $250 cleanup fee in the event a deposit is not charged up front and is due upon receipt. Vendors' failure to pay the cleanup fee results in loss of future rental space without refund, and the vendor's unpaid cleanup fee invoice submitted to collection agencies. Any items left behind by the vendor may result in relocated or discarded by the company and or the venue. The company is not responsible for any loss as a result of the removal of the vendor's failure to take their property with them at the end of the market. Number 44, vendor parking. Vendor is required to park, unload, and load from the designated vendor parking area as directed by the company. Vendor is prohibited from parking in or near the market area. Failure to follow instructions results in the vendor's loss of rental space at the market without refund. Number 45, leaving market early. Vendors must give notice prior to market day if they must leave the market early. Vendors who have sold out of all products or have been provided an exception in another section of this agreement are allowed to leave early with notice. Vendors must notify the company prior to tearing down in case crowd and traffic control is needed to ensure a safe departure. Vendor may not leave a market early because other vendors are packing to leave early. If the vendor leaves the market early without notice, the company reserves the right to prohibit vendor from participating in future markets at any time without refund of any prepaid rental spaces. Number 46, vendor cancellations. Vendor must give written notice of cancellation via email at least 12 hours prior to the start of setup time on market day, unless otherwise unable. Vendors canceling more than 2 times in a 6-month period may be at risk of forfeiting any remaining rental spaces at future markets without refund. See paragraph 58, vendor refunds. Number 47, vendor no-shows. The company has a zero-tolerance policy for no-show vendors. If vendor does not give proper notice of cancellation, the vendor is considered a no-show. No-show vendors may be at risk of forfeiting any remaining rental spaces at future markets without refund. Number 48, vendor behavior. Vendors are expected to be respectful to the venue, the company, fellow vendors, and customers. Vendors are expected to respect fellow vendor rental spaces and nearby areas, keep business discussions discreet, professional, and away from other vendors and customers. Vendors shall not argue with the venue, the company, fellow vendors, and customers at any time. Vendor is required to keep vehicles out of the way of fellow vendors and their rental spaces while loading and unloading. Driving through the market area anytime during the market public times is unsafe and is strictly prohibited. Children must be supervised at all times and are not allowed, in other vendor rental spaces, to roam freely through the market area and must be on their best behavior. Children needing attention must be cared for privately away from the market area and customers. Contact the company immediately if help is needed. Number 49, gift acceptance. The company does not accept gifts of any type from vendors. The company does not accept gifts in lieu of monetary payment for rental spaces. Any gifts left for the company by the vendor at the market are thrown away. Number 50, service dogs and pets. Service dogs. The company complies with the Americans with Disability Act, ADA, regarding the use of service dogs in connection with a disability by vendors. 1. The dog must be a service animal required because of a disability, and 2. The dog must have been trained to perform work or a task related to the disability. Service dogs must be well cared for at the market with plenty of shade, warmth, water, food, and breaks as required by the animal. If the vendor requires the use of a service dog, the vendor must ensure the safety of their dog at all times. Pets. The company does not allow vendors to bring their pets to the market. If vendor needs to bring their pets with them because of traveling, vendor is recommended to make arrangements with local boarding facilities. All exotic animals are prohibited. Number 51, security. The company may provide security at the market. The vendor is required to abide by instructions of security personnel and contact the company as soon as possible after instructions are given. The vendor is solely responsible for the security of their cash, coupons, equipment, goods, inventory, supplies, and any other property. The company is not responsible for lost, stolen, or damaged property. Number 52, termination of rental period. This agreement terminates at the end of the last market date selected by the vendor on the application. Number 53, force majeure. The company is not liable for any failure to perform any obligation under any agreement or for any delay in performance due to events or circumstances beyond the company's reasonable control, including, but not limited to, weather, acts of God, acts or threats of terrorism, government acts, technical failures, fire, or other similar events or circumstances. The company is not liable for any act by any local municipality, county, state, or venue which may result in the failure of the company to perform any obligation under any agreement or for any delay in performance, including, but not limited to, cancellations of markets, placing additional restrictions on vendor participation, changes to market dates, times or locations at venue, failing to enforce laws or ordinances affecting a market. Number 54, disputes. If a dispute and or conflict arises between vendors or vendors and the public, vendors are to notify the company immediately to handle the dispute and or conflict. If the company and or the venue has provided security, the company will also notify the venue security of the dispute and or conflict. In more serious cases, if the vendor feels they need to call 911 for emergency services, please notify the company immediately after 911 services have been called. All vendor disputes with the company must be submitted in writing by email and or mailed to P.O. Box 776, Dickinson, Texas 77539 for resolution. Number 55, limitations on liability. The company is not liable to any vendor or any other person for special, indirect, incidental, consequential, or exemplary losses, damages, or expenses, directly or indirectly arising from the participation or non-participation of vendor in any market or from any other cause relating thereto. The company's liability does not, in any event, whether based on contract, warranty, tort, including but not limited to negligence and strict liability, or otherwise, exceed the amount paid by the vendor for their rental space in this agreement. Number 56, severability. If any provision of this agreement is determined to be invalid, illegal, or unenforceable, it shall not affect the enforcement of any other provision of this agreement. Rather, the invalid, illegal, or unenforceable provision shall be modified to the extent necessary so that it is valid, legal, and enforceable. Number 57, applicability. This agreement is only applicable to the company. Unauthorized use, in whole or in part, by another is strictly prohibited and may be punishable by law. Number 58, mediation. The vendor and the company agree to mediation in the event a dispute resolution is not met through informal discussion. The vendor may request mediation in writing to the company at any time. Vendor agrees to pay their portion of the costs associated with mediation. The vendor and the company agree to abide by the decision of the mediator. Number 59, vendor default. Vendor defaults on this agreement if the vendor fails to meet the terms of this agreement, venue regulations, and or any local, state, or federal laws. Number 60, vendor refunds. Markets are rain or shine. The company does not issue credits, refunds, or move vendors to other dates at the request of the vendor. In the event of a market being rescheduled by the venue and/or a government mandate, the company will move the vendor to the rescheduled market date. The company does not provide refunds or credits to vendors that don't attend the rescheduled market. If the venue and/or a government mandate requires the cancellation of a market, the company will issue a refund to the vendor in accordance with the venue's refund policy or issued refund amount within 7 days of the company receiving the refund from the venue, less any non-refundable fees incurred by the company. Vendors are not moved, issued credits, or refunds for any mistake made by and/or personal or business issue of the vendor, including but not limited to payment with the wrong card, double booking with another event, double booking the company market dates, failure to check or misreading the availability list on the website, vendor cancellations, late shows, no shows, default of this agreement, termination of this agreement, end of term period, etc. The company reserves the right to issue refunds on a case-by-case basis for incidents not included in the aforementioned list as determined by the company. Vendors who submit disputes, fraud claims, chargebacks for credit card charges and/or stop payments for payments they authorized and/or for payments in which the vendor received services, decided to forfeit all or part of the services, and/or breached this agreement are permanently denied. In the event the vendor submitting a fraudulent chargeback claim, the company will invoice the vendor, recover cost for services agreed to in this agreement, submit any failure to pay an invoice to collection agencies, and/or seek any legal remedy allowed by law. Number 61, written communication and vendor insurance. Inquiries, requests, and disputes must be made by the vendor in writing to K.M. Parker Enterprises, LLC, Company, at texastradedays@gmail.com, or mail to P.O. Box 776, Dickinson, Texas, 77539. The company does not accept texts, social media messages, or verbal messages as approved forms of communication when conducting business. The company does not enter into verbal agreements. Vendor insurance. Vendors requesting certificates of insurance from their carriers must submit the following information to list the company as an additional insured. K.M. Parker Enterprises, LLC, P.O. Box 776, Dickinson, Texas, 77539. The phone number is at 346-439-9318. Number 62, acceptance. The company will provide the vendor with notice of acceptance or denial through the company website and/or the email address provided to the company by the vendor in this agreement. Signatures. The company accepts digital signatures for online agreements and original signatures for paper agreements of the vendor. Number 63, hold harmless. Vendor, in consideration of being provided rental space at any Texas Trade Days markets, agrees to the terms and conditions of current rules. 1. Vendor shall indemnify, defend, and hold harmless K.M. Parker Enterprises, LLC, owners, brokers, agents, coordinators, servants, employees, and volunteers from and against any and all loss, damages, liability, claims, suits, costs, and expenses whatsoever, including reasonable attorney fees, regardless of the merit or outcome of any such claim or suit, arising from or in any manner connected to the willful misconduct or negligent acts, errors, or omissions of the vendor and its agents and employees in connection with the vendor's participation in the Texas Trade Days markets and in the performance of services, work, or activities under this agreement and the Texas Trade Days 2024 vendor rental agreement and policy. 2. Vendor acknowledges receipt of and agrees to comply with each rule, regulation, procedure, term, and condition set forth in the current version of the Texas Trade Days vendor rental agreement and policy terms. This version is the TXTD VA V8 2024 1013.